I'm with Vadim Glozman. Mr. Glozman has represented the former business manager of R. Kelly, has worked for Ed Genson, arguably the dean of Chicago criminal defense. And by his own account, he is not a prominent criminal defense attorney, despite having achieved a high-profile acquittal in an era where the acquittal rate is 18% in federal court. Recently, he obtained a $45 million verdict working with a plaintiff's firm from Chicago, right?
That's right, Kralovic, Jambo, and Schwartz.
Yeah. So, Mr. Glozman, it's an honor to have you as a guest, and I want to first congratulate you on your recent win and ask you to comment on, first of all, your professional trajectory and kind of give us a look into your how you came about as a criminal defense attorney, and then to speak a little bit about that recent acquittal.
It was really easy for me to get into this. I was kind of ignorant about the law, and I thought all lawyers were criminal defense lawyers. That's a joke, but after college, I got an internship at the state's attorney's office right before law school started, and I worked for who is now Judge Alex Gillespie up in Skokie. And I told her while I was working at the state's attorney's office, I'm really interested in criminal defense work. So she introduced me to her husband, Mike Gillespie, and he hired me as his law clerk. And at that time, his dad was still partners with Ed Genson. We were all in the same suite, and there came a point where one of Eddie's associates quit to join the public defender's office, and he was looking for a second associate. So they brought me on as a law clerk. I was still in law school, about a year out from graduating, and he was bringing in all these people to interview, and he would never talk to me. They put me like in the back corner somewhere in the big suite and said, "Here's 100 discs of Discovery, print everything, and don't talk to me very much." And he was interviewing all these people, and I really wanted to work there. I looked into his history, who he was. I'm like, this is who I want to work for. So I walked into his office. My heart is like beating out of my chest. And he's like, he looks at me like, "What do you want?" And I said, "I know you're interviewing for associates, and I'd like to be considered." And he looks at me and goes, "You already are. Now get out of my office." And I don't know what happened, but he never hired anyone. He waited for me to finish law school, to pass the bar, and brought me on as an associate. I like to say he saw something in me, but I really don't know the answer.
That's a really interesting origin story, if you will. So you had already sent him your resume, your application, or he knew about you through Gillespie, or?
Well, he knew about me through Gillespie, and he hired me to be a law clerk at that time, but they wouldn't trust me to do anything. They were working on these big federal cases, and I was just some kid in law school. And I don't know. I figured I'd say something, and if I didn't say something, I might lose the only chance I had.
So for the listeners, can you describe who Gillespie is and kind of their history and how Genson and Gillespie came to be partners?
So Terry Gillespie was a state's attorney for Cook County State's attorney. And, Eddie had a big criminal practice, and he was kind of switching over to doing primarily federal work, but he was still getting calls on a ton of state cases. And Terry had a really good reputation in the state's attorney's office. He brought him on, and I think after a few years, he made him partners, and he did most of Eddie's state work. And obviously, Terry became maybe the second most prominent criminal defense attorney after Eddie, and it was a powerhouse. Any case worth talking about came through their doors during their partnership.
So what kind of cases did they work on? I know that there was a lot of organized crime cases, public corruption, if I'm not mistaken.
Everything. They had celebrities, like you said, public corruption. They had a lot of outfit cases. They had everything. What makes me sad a little bit is I think I was born in the wrong era, and I came to work for Eddie at the end of his career, and I always told people
organized crime has been stamped out already.
Yeah, I would have loved to work for him like in the 80s or the 90s. I know at one point he represented almost all the people at the Mercantile Exchange who were getting grand jury subpoenas or getting indicted. I
Very
think
cool.
he actually told me a story one time about how he got into doing federal white collar crime. And there was a guy from his neighborhood who was indicted on, I think, some kind of tax fraud or tax evasion. And he came up to Eddie and he said, I think it's easier to teach tax law to a criminal defense attorney than criminal defense to a tax attorney. And Eddie took on the case and got an acquittal, and
Wow.
I think the rest is history.
Wow. With no prior experience.
He was really smart.
Yeah.
Even, at the end of his career, I know he had, some disabilities, and people would think that maybe he wasn't as sharp as other people. It's just not true.
Oh, yeah.
He wasn't as the smartest lawyer I've met.
Can you tell me a little bit about his disabilities? I know that he had dyskinesia, which is kind of these involuntary movements and things like that. And I know he suffered from cancer and things like that. Can you talk about kind of how that impacted him as a person, how it impacted him in front of juries and as a lawyer?
I think it's actually called dystonia. It's a really rare
Sorry,
disease.
dystonia.
I think I might be completely off on this, but I think it kind of goes through like Jewish lineage when you get it. Very few people have it. There's nothing to cure it, but I would not say it was a disadvantage at all. And I think it actually gave him an advantage. And I think he
heard that.
used it to its advantage. Juries liked him. Juries sympathized with him. And, I'm not one of those lawyers that thinks it's always in the best interest to be the flashy lawyer or the fancy lawyer in front of a jury.
But he could get away with it.
Yeah, Eddie would go up there and he'd have like papers all over the place with like sticky notes and, not organized at all, like pieces of paper where you couldn't read any of his handwriting. It was kind of fumbling around, but it worked because it was all strategic. He was doing it on purpose, and it was so smart. And, he had to sit when he did his cross examinations and opening and closing statements when I worked for him. But you could hear a pin drop when he was giving a summation or an opening statement. I mean, everyone was just drooling over all of his words. I think one of his biggest strengths is he could have, he had a fact pattern, and you could show the fact pattern to 10 lawyers and they'd all say the same thing about it. And he'd look at it and see something completely different. And I don't know if that's something you could teach. It just, he's done so many cases, and he had such a unique ability to just, I don't want to use the word spin because it wasn't spin. It sounded like what he actually saw was the truth. At least the way he talked about it. It was very impressive.
This is a quality. Part of the reason I do these interviews is to determine the qualities of the great lawyers of our time. And one of them is to spot unique defenses, like defenses that no one would have thought of, that have their own narrative coherence and their own truth to them, and that are effective. I don't know if you've heard of Racehorse Haynes out of Texas, but once he defended this woman called the Kissing Bandit. She would kiss like baseball players. So she like fell into she jumped into the field and she ran over to this famous baseball player and kissed him. And like, he got all upset about it and like accused her of who knows what. And she got indicted. And, his argument was that she had fallen into the field. And then once she was there, she walked over to him to talk to him, and her cleavage was so large that she had bent in, like that she was off her balance and had bent into him and kissed him. And it was an acquittal. It was an acquittal. And like, show me the lawyer who would think of something like that. And obviously, Genson was of the same mind. These very creative, divergent thinkers. Can you tell me what kind of an impression he left on you?
I owe everything I have to Eddie. I really do. I think I have more credibility than I probably deserve because I worked for him. I'm still trying to learn. I'm a nerd about it. I'll start missing him, and I'll Google him, and I'll start reading old articles about Eddie that I've read 100 times before, just because, maybe I'll see something new or I'll remember something. And he had this ability of just being liked by everyone. He'd fight as hard as anyone else, but then everyone loved him after the trial. During trial, it was battle mode. And then after the trial, even if the prosecutors lost, they loved him. He was, I'm always going to strive to be him. I don't know if I have the qualities. I don't know if anyone has the qualities. There's a reason there's only, a handful of lawyers we talk about in history. or of that caliber, but it's something for us to strive to be and, take the lessons that we can. My wife always makes fun of me for being a nerd, but one of the things I do is I find all the criminal defense lawyers' biographies I can, and I read the books for fun. And that's my leisure reading, is just seeing what they did and seeing how I could maybe bring that into my practice.
I thought it was just me my whole life, that I was the only one that was obsessed with this. And I'm glad to know that that's not the case. You and Neil Rockhind and so many other lawyers have really kind of given me a sense of community in that respect. I do the same thing over and over and over again. I will read the same articles. For me, it's Jerry Spence, because I'm from Wyoming. And so he is a fantastic lawyer, and all I do is read the same articles about Jerry Spence. I know every word he's written, all of his foibles, his successes, everything about him. I know entirely. And
well, maybe after this we could talk, and I'll give you some book suggestions that I've had. Maybe you haven't read them yet.
Absolutely. I would be I'd be happy to have any book suggestions that you'd give. So let me ask you, your recent acquittal. I know that you had a history, or did you, with R. Kelly because of Ed Genson, and that kind of turned into representing his business manager. Is that kind of how that transpired, or?
So I never had a relationship with Robert. The first time I met him was during this case. I started working directly for Eddie about 5 years after their acquittal.
Okay.
But Darrel McDavid, the business manager, he would still come around, and Eddie was one of his mentors. He loved Eddie, and he'd come around, and I'd strike up a friendship with him. And this case was kind of put me in an interesting spot, because I've had a lot of cases where over the years of me representing someone, I'd become friendly with them and consider them friends to this day. With him, I was already friends with him, and then one of my friends got indicted by the federal government. So it kind of was a little bit more personal to me, and that's really how it came about. Eddie was still alive when he got indicted, and I was a very young lawyer. I'm still a young lawyer. I was much younger then, and Eddie told him he should stay with me because I'm going to lead him down the right path. And so, I helped put together a team of attorneys, and it worked out.
Who was on your team?
Bo Brindley. So he took lead. He's a very experienced trial lawyer. He's tried a lot of federal cases. He's had a lot of success. And his associate, Mike Thompson, was on the team. My associate, Matt Kralovic, who's a really smart guy, probably one of the best researchers and writers I know. He gives me a lot of credibility. He was on our team. And, we were able to put together a good theory and present it to the jury. And they, I don't think we won this one because, we did something super clever. I think it was the right verdict, if that makes any sense.
No, it makes complete sense. You're saying that, like, a jury evaluating based on common sense would come to the conclusion that he was innocent of what he was accused of. So can you
the way they charged this case was very dangerous, the way I thought, and it could set a dangerous precedent. There was an issue with the statute of limitations for the obstruction of justice charge, where they had no evidence and no facts to back up their claim about why the statute of limitations was extended the way they said it was, and they just wanted the jury to infer something based on nothing. And the child pornography charges, the receipt of child pornography, I understand why they charged it, but it's not the spirit of the law. You don't charge it for what they did. It's more of like the typical child pornography cases. What those are about. We don't need to go into specifics, but I didn't like that. So that gave me another edge to want to beat this case, is because I thought it was a dangerous precedent that they were setting by the way they charged it. Another thing is that the cooperators they had in this case were probably the two most dishonest people I've ever seen testify in court. And I've seen a lot of dishonest people testify.
Hear that a lot in
by far the most dishonest.
Yeah. The sentencing guidelines, as you know, just incentivize snitching. Well, I wouldn't even call it that. Like, incentivize cooperating, and it's just the quality of the cooperators that you get is it's really abysmal. but the jury seemed to give him a lot of credibility. What did you do in this case to diffuse the testimony of the cooperators, and what made them uniquely have credibility problems?
You know, the main guy, Chuck Freeman, he was just a criminal. He was a con artist. He was a thug. And I mean, he admittedly, committed crimes, and they just gave him full immunity. And same with the other witnesses in the case. And they just completely contradicted themselves over and over again. They contradicted each other. There were three cooperators. The third guy completely contradicted the first two. The first two were contradicting each other. We got Facebook messages where one of them is trying to tell the other one what to say. And he's just like, I don't remember that happening. It was, I don't know. I've never seen anything like that. And I'm sure you're aware, before a federal trial, the government will file a Santiago proffer showing why they think co-conspirator statements need to come in, that they're not hearsay.
Yes.
Usually they're pretty close. What they say is going to be said is pretty close to what's actually said in court. This wasn't even in the same ballpark. You read the Santiago proffer and like, okay, this is going to be tough. And we're in court and they're not testifying to what they said they were going to testify to. And so one of the things we had to do was, be able to, be on our feet and pivot with what they were saying. And the only way to do that is to be prepared. And, we went over everything so many times. We put our entire practices on hold just to focus on the case.
Can you describe, well, first, I think I want to commend you for taking the case of a friend. I mean, I don't know that I would have the same courage in your position to say, I think I can give you my absolute best, even though my emotions are definitely in this for you. And you took the case, and that seemed to be a strength for you rather than a weakness. And so I want to commend you on your courage to do that. With respect to these cooperators, can you explain a little bit what in particular they were testifying about and what made their statements contradictory? And that might require a more thorough backdrop of the charges against your client. But and if you had anything else to say, I'm sorry.
No, you're good. So one of the big issues in the case was that they were saying that my client was one of the people trying to collect these sex tapes with underage girls that were around the country with R. Kelly. And this was all while he was under the Cook County indictment. And Chuck Freeman, the count that was germane to him was in August of 2001, my client was supposed to have been down in Kansas City, where Chuck lived, receiving the tape from him. And that was the substantive receiving child pornography count. And in order to get the tape, they had to pass a polygraph test. They had to pass a voice stress analyzing test. And only after that would they pay him for the tape. But the polygraph that the government put on said my guy wasn't there. The voice stress test analyzer said my guy wasn't there. Jack Palladino, who was the celebrity investigator that R. Kelly used, who was there, and we were able to get his records in. His records showed that my client wasn't there. My client testified he wasn't there. And the way Chuck was testifying about my client being there was contradicted by the own documentary evidence the government was putting in, the witnesses they were putting on. And, it didn't follow a coherent timeline. And I was actually, out of all the counts, I was surprised that they stuck by this one, because there was so much just contradicting him. And I think they felt like they couldn't go away from it, that they had to. But in order to believe this criminal, you had to not believe Jack Palladino, who was, he represented Bill Clinton and the whistleblower in the tobacco litigation, every celebrity possible. The polygraph and voice stress analyzer, people who were both law enforcement at the time, my client, obviously, and we put on another witness who works for Kim Fox right now, actually, and he was a DA task force officer back then for the Chicago Police Department. Wow. He had gone down there with Jack, and he said my client wasn't there. So you had to not believe all of these law enforcement officers and believe this guy. And, everything from there kind of spiraled. It made no sense.
Why did they bring this? Well, I mean, why? It's pretty clear why. But
I think that's above my pay grade.
well, I mean, maybe it's above their pay grade. I think it's federal prosecutors, by and large, are, I find, highly vindictive and willing to rely on the testimony of cooperators that are morally bankrupt, people that they would happily throw in cages if they weren't cooperating. It does turn my stomach. And you have the pipeline from federal prosecutor's office to big law, which is very disgusting, because you have them basically building their legal careers prosecuting people who have no money, who are like the so-called lowest of the low, who are really, is just a way to say they're marginalized. And then they go and they use this to transfer into white collar defense and defend people who are well off and accused of crimes. And there's nothing wrong with doing that, but their motives there are quite telling. And they like to say that they've left the prosecutor's office undefeated. And that's not a big statement for a federal prosecutor to make, but they like to make it. And I mean, I think it's pretty clear with this association to R. Kelly, one could make their career. You read a lot of lawyer bios. Wouldn't it be nice to have in your lawyer bio that you had some hand in the destruction of the R. Kelly empire, something that no one will ever feel sorry for, and that people will give you a lot of moral points for? It's a difficult thing to turn down. What do you have to say about that? What do you speculate would be their motives in bringing a case like this?
It's because they lost in 2008. I mean, this is what it all stems from. And my understanding from talking to some people who were around back then, I'm not going to name any names, is the federal government wanted the case then, and the Cook County State's Attorney's Office wanted to keep it. They thought that they had a good case, that they were going to win, and they decided to allow them to keep it. And, we know how it turned out. I don't blame them for bringing it in federal court, but I think if they were going to do it, they should have done it right away, not wait so long. And I want to go back to what you said about, using cooperators. I understand the value of cooperators, especially if you're in a situation where there's something to corroborate what they're saying. If you have Title IIIs that corroborate them, or emails or text messages in a white collar case to corroborate them, fine. But you're putting these people on with absolutely nothing to corroborate them on, where they're contradicting each other, and you would think they would know this before they went to trial. I actually went to lunch with a ex-US attorney yesterday, and we were talking about the case, and he told me that, whenever he brought a case, he would map out the trial before he indicted the person. So he would know exactly what to expect if they went to trial, because his position was, I don't want to indict them unless this is a slam dunk case, which, I mean, I agree with. If it's not a slam dunk case, you shouldn't ruin someone's life.
Yeah, good for him.
He really opened my eyes, because, prosecutors are people too. They're all different. Some work harder than others. Some are better lawyers than others. But I think if they have so much discretion, and the decisions that they make affect someone's life so monumentally, that I think if you're going to return a federal indictment against someone accusing them of horrendous crimes, you have to be as close to certain as possible that you're going to win. Because even now, you get one of the rare acquittals in federal court, or, you get one of the few people who get probation and don't have to go to jail, your life is still ruined. You can't expunge a federal case. You can't, it's hard to clear Google. It's hard to clear all the news.
You're financially ruined.
Come up. Yeah,
most likely. Yeah.
Most people, yeah. A lot of people get lawyers appointed in federal court because if you're going to put on a good defense, it's expensive. Good lawyers are expensive, experts are expensive. And I guess that's my criticism. I don't really want to comment on prosecutors going to big law firms or working as criminal defense lawyers. I think a lot of them turn out to be good criminal defense lawyers. There's certainly some that are in my building who were prosecutors for a short period of time who have become some of the most prominent, well-known criminal defense attorneys. And, they're as good as anybody else, but I don't disagree with a lot of the things that you're saying.
You know, I don't know. I work at Georgetown. I had the opportunity of taking a class from some prosecutors in the public integrity section. And it reminds me of the prosecutor that you're describing. A lot of, integrity, obviously, and a lot of this understanding that the power that the law gives them is so tremendous that you have to restrain yourself. You really have to restrain yourself and check and make sure that you are bringing the case truly based on the facts. And there are some prosecutors I've spoken to who share in that philosophy, and more power to them. I wanted to pivot and ask if there were any other criminal cases that you would classify in your career as kind of hallmark cases or extremely important cases or formative cases, and if there were any lessons that you had learned from those.
I mean, you learn a lesson in every trial you do. They kind of take on a life of their own, and something always comes up that's never come up before, and you got to think on your feet. When I worked for Eddie, I think I was still a first-year lawyer. I wouldn't say I wasn't really a lawyer on. I mean, I was a lawyer on the case. I had my appearance on it. I sat through the trial, but I really didn't do anything besides observe. And he told me, you could observe. You're just gonna have to do the rest of your work outside of trial hours. And I said, that's fine. I want to be here for it. And it was the trial of Bo Brinley and Mike Thompson. They are two lawyers, criminal defense lawyers. They were indicted for allegedly coaching their witnesses and clients to lie on the stand. And I think that was a really important case. It was also a dangerous case. You could tell that, the whole criminal defense community, not even the criminal defense community, a lot of lawyers in Chicago paused a little bit because, you have to take your clients at their word. It's not your job to, pry them or say, you know what, you're lying to me. You just got to put on the best defense. And if they tell you something, you got to work with it. And lawyers were scared that if they were going to do this, they were going to be accused of the same thing. So no one wanted to put on a defense.
Chilling effect.
And what I've learned with the trials I've done, and I've heard some judges even say this, if you have a defense, put it on. Don't just rely on this notion of beyond a reasonable doubt, because what does it really mean? You can't even define it. You get an objection if you even try to get close to it. And people want to see evidence. If you have witnesses that you could put on, you put them on. If you have a client that, is willing to testify and you weighed the risks of testifying against not testifying, you want to be able to put them on. You don't want to say, you know what, I'm too scared. I'm too nervous to put on a defense. I'm just going to cross-examine the prosecutor's witnesses and do my closing argument. I don't know if you're doing your client any service doing that.
I heard this described as the old way of trying cases, like way, way back in like Irving Younger or like Francis Wellman times. They used to just try it based on reasonable doubt alone. But, recently, like you've said, it seems that the literature on trial advocacy requires it. Like you have to tell a story that's believable. You have to present a kind of affirmative, not in the legal sense, but in the logical sense. You have to present something affirmative to the jury rather than just negative, rather than just appealing to reasonable doubt. Have you heard the concept from Thomas Mesereau, the idea, Michael Jackson's lawyer, the idea that you shouldn't even bring up reasonable doubt because it looks very slick? It looks almost like you're trying to appeal to some technicality. Or do you have a particular way of bringing it up that emphasizes its integrity as a legal principle?
I agree with it, I guess, almost in whole. I bring it up. I think the jurors need to know about it, but I don't spend a lot of time in my arguments, talking about what reasonable doubt means, or, trying to skirt around the law of not being able to define it. I tell them, you have to find them guilty beyond a reasonable doubt. And then you go through the facts of the case and you point out, like, is that really beyond a reasonable doubt? Is that a reason to doubt the government's case? And I intertwine it that way. But I don't have, long sections of talking about the importance of reasonable doubt or things like that. You have a limited amount of time and you want to focus it on the facts of the case. And I think, I think enough people watch Law and Order or whatever they watch on TV to kind of have an idea of what beyond a reasonable doubt means.
By now, yeah, certainly by now. Um, do you have any comments on what true crime has done to the trial of cases? I mean, certainly with R. Kelly, you could argue that the federal government's decision, someone could argue that the federal government's decision to bring an indictment was almost strategically after the press got back on the case, after the recent documentary from Netflix. What impact have you seen based on those kind of Netflix documentaries or true crime, or even just in the media? What has that done? How do you address it? Any
I think
comment?
it's actually worked both ways. I think the true crime has put pressure on some prosecutory offices, to bring cases that they weren't being brought. But I also think on the other side, they've brought to light maybe some kind of wrongful convictions or improper cases, and you get lawyers trying to exonerate innocent clients. So I think it works both ways. I think the problem is getting a fair jury. And just going back to the R. Kelly case, it's fresh in my mind. R. Kelly's or Robert's attorneys, they spent a lot of time in voir dire talking about surviving R. Kelly and trying to find out, who watched it, how much of it they watched it, how it affected them. And it's tough. They were put in a tough position. But, I think jurors, people need to, they need to be given more credit. If you frame your arguments the right way and the jurors understand the gravity of the situation, I think you're able to put them in a mindset where they know that, the courtroom is a different world than what's outside, and they could put their biases aside. And I think R. Kelly verdict proved that. I mean, they could have easily just found him guilty on all counts and not looked back, but, they were able to put some of those things aside. So I think true crime, I'm not a big fan of it. I don't really watch it, but I don't think it's that bad. I think it brings things to light. I think people kind of learn more about the criminal justice system and they see both sides of it.
Dershowitz has an interesting, whatever you think of him, has an interesting comment on this. He's like, not everyone gets a Netflix documentary, and that's unfortunate. So there's a limitation on the media's ability to cure wrongful convictions, but certainly they have an established place in doing so. Like I'm thinking of The Staircase, if you've ever heard of that. Michael Peterson, yeah, it's like thinking of that in particular. Let me ask you, I want to pivot to cross-examination. Cross-examination is the most universally applicable skill I think the criminal defense attorneys do, because it's used in obviously every branch of trial law by necessity. And when civil lawyers have questions about cross-examination, they go to criminal defense attorneys, and when they have questions about direct examination, they go to prosecutors. And it makes sense why. The sheer amount of trial experience that we get in criminal law, we're very fortunate, very lucky to get that. Obviously due to some very unfortunate systemic issues, but nonetheless. So I guess what I would ask you is, what innovations would you have to offer in cross-examination? Things that you've seen that you've never seen elsewhere, like someone does something and you're like, wow. I mean, it might apply to a very hyper particular set of facts, but anything that you've seen that's atypical, something beyond like looping or the basic techniques.
There was a cross-examination that was done in Bo Burnley's trial of one of the cooperators, and they had her on a recorded jail call, talking to, I think it was her boyfriend or her husband, saying all of these things in a hysterical manner that kind of contradicted what she was talking about at trial when she was testifying. And it would have been easy to just play it. But what the lawyer did was she turned every sentence that she said in the recording into a question. And she just read it back to her and made her, you said that, didn't you? And I thought that was one of the better cross-examinations I've seen. And, I felt chills going down the back of my spine. You could just, you could feel the momentum of the trial changing right at that point. And she was one of the first witnesses, if I recall correctly. So it's things like that. I think everyone has a unique style. I think one of the main things I would suggest is be ready to pivot. You got to know the case so well that you might have a cross-examination mapped out, and you think you know what the witness is going to say, but he says something different that actually helps you more than you thought it was gonna. So you got to be able to go down that path, even though you're not ready to. And that happened to me one time. I was doing a federal trial in St. Louis, and I was cross-examining the main agent on the case, and
Special agent.
Say this again.
I said special agent. Remember, you have to call them special agents.
This guy wasn't very special.
Oh,
but
okay.
I was cross-examining him. Everything was going as I planned. I was getting all the points across, and I got to the last section of my cross, and it was all based on some of the statements he made in the grand jury. And when I asked him about one of them, he told me that no, he was wrong when he testified about that. And I wasn't expecting him to say that, because I wanted him to say what he said in the grand jury was true. So I took that as an opportunity to say, you know what? You were under oath there, just like you are here today. You knew that your testimony was being used to bring a federal indictment against someone, that they were going to go to jail because of what you were going to say. And you're telling us now that you weren't sure. And now you're sitting here under the same oath, still testifying. And, I went down this whole path, and I'm like, what else are you not sure about? And I didn't care what he said at that point. Usually my last question, I don't really care what the answer is. I just try to make a point to the jury and I walk away. And, that was a shift in the trial. I think maybe I'm just patting my own back, but
no,
I had no business getting an acquittal in this case, and we got a full acquittal. My client was, I think, caught red-handed. He had his hands in the cookie jar, and we got a full acquittal. And I'd like to say it was because of that.
Wow. I think that's powerful. I've seen it recently. In fact, today, Ross Guberman. Do you know who Ross Guberman is? The guy who developed.
The name sounds familiar, but I'm not sure.
He's like this legal writing expert. He was actually, maybe it wasn't him. Maybe it was some other legal writing expert on LinkedIn. But their argument was, if you look at the trial transcripts, they were talking about a civil case, and they're like, here was what the plaintiff. Here was the transcript for the plaintiff's lawyer. And it's like, here was the question they asked, here was the answer they got. And then they looked at the cross-examination, and they took the same schedule of events, right? And they extended it out, even to the point where if they're looking at the discovery and they're like, okay, she went outside, like she was in the house and she went outside. We know those two things from the discovery, but it means she opened the door. So they add that in. Like, in order to make it seem like it was a longer amount of time for her to do something, they ask more questions. They go through every event, and pretty soon the jury is like, Jesus, this must have taken her a while because you're spending a decent amount of time on it.
That's definitely one of the things I learned from Eddie, was to really break it down into as specific as quick questions as you can. I mean, in certain situations, at the end of the day, I think cross-examination, the style of cross-examination depends on the witness and what you're trying to get out of them. But if it's an important witness, really breaking it down really helps, because, you make it your timeline, and sometimes you learn things you didn't think you were going to learn.
Let me ask you, do you think that we're in like this, do you think that there's anything innovative to be developed in cross-examination, or do you think we're just in like this age of refinement, like making existing strategies better?
I'm sure there is. I might not be the person to ask about that. I know my cross-examination gets a little bit different every trial I do. I learn, I get better. I see other lawyers do it. I change my style. I change my tempo. I change the types of questions. I change, the order I do things in. And, it's cross-examination is an art. So I don't know if there's ever a final product. I think you keep evolving it. And there's much better lawyers out there than me that are helping the cause. And, there's no one way to do it. There's pillars that you could follow, but there's no one way to do it. I'm always guilty of breaking some of the rules they teach you about cross-examination. And I think some of my more successful cross-examinations was when I did break those rules. You
Talk
just got to
about
be
that.
careful
Yeah.
when you do it.
Talk about that. Thomas Mesereau said the same thing. Rusty Harden has said the same thing. Asking what questions, open-ended questions and cross has paid off.
That's exactly what I was going to get to is, sometimes my co-counsel looks at me like I'm crazy for asking an open-ended question, but sometimes open-ended questions aren't going to hurt you no matter what the answer is going to be. You have to be strategic about it. Or, sometimes you're backed up into a corner, you don't have much to work with, and you got to find something else out. But I think some of my more successful ones I've had, I asked open-ended questions. And, I found something out that I wasn't, in the know about, and it ultimately helped out the case.
And how can you find anything out if you're only asking, the very tight leading questions? You have to ask the open-ended questions if you're seeking information. And how would you say criminal defense attorneys can temper the risks of adopting that kind of strategy? Because it is risky.
You have to know the case inside and out. And that's another thing I learned from Eddie is preparation. You have to be more prepared than the prosecutors are. You got to be the most prepared lawyer in the courtroom. And if you know as much of the universe of facts as you can kind of guess which direction the open-ended question is going to go. Or you can say, okay, well, if he says this, I can go down this route. But if he says this, I can go down this other route. I've done this before is when I'm writing out my cross-examinations, I do like 2 or 3 versions of one section, depending on what they're going to answer. But then, I fumble around with my papers a lot. I lose track of where everything is on the podium, and I end up going off the top of my head for half the time anyway.
That's funny. I've heard that from a lot of lawyers, and I've heard, I don't know if I mentioned him before, Jeffrey Lichtman, in an interview that he did with Neil Rockheim, has said that he tries to, in his trial binder, incorporate a version of the cross-examination for every eventuality based on the witness's answers. And like you were saying, that requires this enormous amount of preparation. I've heard it said that those were the first 3 rules of trial law: preparation, preparation, preparation.
That's right. I think that's what separates the greats from the good lawyers is they're willing to put in the time to prepare.
One thing I've heard, and I want to ask your take on this, I've gotten some weird looks, but like having an evidentiary rule ready for each question you ask. So if you do have a script and the witness stays on paper for a lot of it in cross-examination, and you have an evidentiary rule listed next to each question, and the prosecutor stands up and objects, and you say, Your Honor, this is in under 2003 or whatever rule it is. There's no 2003, incidentally. But you say that, you glean credibility, I think, in the court's eyes, if they're a fair court. What do you think about that? I think that's overkill?
We did that in this recent trial for Darrel McDavid. Not for every question, but during his direct examination, we knew that certain objections were going to come based on the way we were structuring his questions. And so we were ready with, the explanation or the rule about why it comes in. I don't do it for every question. I usually, have a pretty good idea of what the hearsay exception is or what the relevance is, or I'm just ready to rephrase the question. It doesn't matter to me. I'll ask the same question 4 different ways until the judge allows me to, finish it.
You're not particular?
No, it doesn't matter to me. One of the lessons I've learned in cross-examination is if you have a point you're trying to make, or you have a question that you need the witness to answer, you don't give up until that question is answered, whether it's because of evidentiary objections and you got to figure out a different way to ask it, or if it's just, a difficult witness not answering the question. A lot of lawyers I've seen, they see a difficult witness, they won't get the answer they want right away, and they're like, okay, well, I'm just going to move on. And my advice is don't do that. Press them until you get the answer. Don't let them off the hook, because they got to understand that they're playing your game. You're in the power position, not them. They have to answer your questions, and you're not going to fall into the trap of letting them control what's going on. You have to be in control, especially when it's a difficult witness.
And if you do this for every issue and get that ultimate point that you wanted out and move on to the next issue, after the third or fourth time you do this, you basically train the witness to realize that anything that you say, you have the answer behind your back. You have them on paper. You have a way to pin them down. And I think eventually they might just start agreeing with you.
Well, that happens all the time. If you're going to go after a witness's credibility and they see that you have an impeachment on them from the very beginning, whether it's a grand jury statement or a 302 or whatever it is, they're going to let you have what you want to have by the end of it because they just want to get out of there. One of the witnesses in this last trial, Bo Brinley, crossed her, and then Jennifer Bonjean was supposed to cross her the next day because the day was over. And she got so beat up that the prosecutors had to come out in the morning and say, we just want to disclose that she was refusing to come to court today. And we had to tell her that if she wasn't going to come, the marshals were going to bring her over. And so on Ms. Bonjean's cross-examination, that was the first question she asked. So you didn't want to come here today?
Wow, that's great. That's great. What would you describe as your personal style in cross-examination? Like you explained that every cross is different. Everybody does cross different. What is your style of cross-examination?
It really depends on the type of witness. I'm not one of the kind of people that'll ask questions just to ask questions. I like to get my points across and get out of there. I think I try to keep a serious tone, especially if it's, you know, a difficult witness or a cooperator or one of the main people. And sometimes I try to throw a joke out. You know, if it lands, it's really good and you think you're a genius, or if you're like me, you do it too much and you flop on your face and there's crickets. But
you need the canned laughter.
Yeah, so it really depends. Sometimes there's witnesses where I don't want them to be liars. I want them to be telling the truth. And I play up their credibility. And then I ask them just, about facts that the prosecutors didn't bring out. Or, sometimes I just ask questions about things they don't know about that are important to know and maybe they should know about. And all I want them to say is, I don't know. It's really just different on every witness. I don't think there's one way to cross-examine everyone.
There are some cases where the facts are such that people would call them, commentators and bookmakers and everything else would call them impossible cases. I can think of Casey Anthony being an impossible case. Daughter's missing, you don't call her in, you make up a bunch of these characters like a nanny that's taking care of your daughter, a job that you have, inventing this stuff. And it seemed like an impossible case, but nonetheless, they were able to secure an acquittal. Nonetheless, inarguably, you've had similar impossible cases in your career. What is you don't become Ed Genson trying easy cases. When you're faced with an impossible case and your client wants to go to trial, what do you do?
If you can, I think what I've seen be the most successful is sometimes there's one piece of evidence that's really bad for you. And I don't think it's right to ignore it. I think you got to figure out a way to make the bad evidence your evidence. And once you could do that, you're going to be in a good position to win the case because you're not shying away from it. You're not trying to, say, hey, don't think about this. We got all this other stuff. No, you take what they're using and you make it exonerating. And it's tough. I mean, it's easy for me to say it now, but I think the cases I've seen where I think they would be impossible, that's what happened. You got to embrace the bad facts. You got to make the bad facts work for you. Because, to be fair, if you're indicted in federal court, most of the facts are probably pretty bad. Yeah,
certainly. And the barrage that you're in for, certainly with federal prosecutors. That strategy makes a lot of sense to me. I thought about it recently on a case that we're working on right now at the office. But with Casey Anthony, for the viewers, applying your strategy, Mr. Glozman, what Jose Baez and Cheney Mason, who recently retired, what they did in the opening was to just explain all these bad facts as a way, saying that she was delusional, basically. That when she was partying, she was in denial about her daughter's death. And then when she was inventing all these characters, well, that's because she's a liar, because she was trained to lie, because that's how she survived in her household, because she had to deny a lot of things, including the fact that she was molested by her dad, all this other stuff. So what they did is they took the worst thing. Why didn't you call the police, report your daughter missing? They incorporated it into a story about a naive, young, delusional, in over her head mom, single mom, and made her sympathetic. So I think you're absolutely right. Can you comment a little bit on the judiciary and what makes a good judge in federal court, especially since voir dire is so contingent on how good your judge is, how fair they are, honestly.
That's the only thing I want from a judge, is to be fair, to call balls and strikes. Unfortunately, that doesn't always happen, but that's really all I expect. I don't really care too much how they treat me. I'm really good at putting my ego aside. I think my client's best interest is always at the forefront. And you know what, if my ego gets bruised along the way, protecting my client, I don't really care. But all I really expect from a judge is, I want you to be fair. And I don't care how you get to fair, as long as you get to fair. But I think that's one of the biggest variables in a case is who the judge is. And I learned that early in my career when, you're interviewing a new case that they want you to come on or something like that. One of the first questions I now always ask is, who's the judge? Because I think that's going to shape how you handle the case. It's going to shape the strategy going forward. It's going to shape, your expectations about going to trial. And, going to trial is always a cost benefit analysis. And part of the analysis should be, is the judge going to give you a fair trial? Or is the judge going to hurt you at sentencing for exercising your constitutional right to a trial? So go ahead.
I've heard of lawyers objecting to that, to try to get it up to the Supreme Court, saying whatever the first offer was, why does that change after my client exercised their constitutional right? Why does the sentence have to now be, why is there a trial penalty? That's basically what they're trying to litigate. There's a lawyer out of Connecticut that is constantly making these motions to try to get it up. Do you have any faith that the Supreme Court will take up the issue of the trial penalty? And if they do, whether it would be good for criminal defense attorneys?
I think more people will go to trial if you know what you're looking at one way or the other. There's no downside. That's what sways a lot of people about not going to trial, especially in federal court, is the way the guidelines are set up is they automatically favor someone who pleads guilty by subtracting points for accepting responsibility. And, then you add the extra 3553A argument that, my client acknowledged what he did, and you kind of play up the acceptance even more than the points allow to go for a below guideline sentence. And that all kind of goes away when you go to trial. And there's some judges that I've seen that won't give you a penalty for it. They'll weigh the guidelines for what they are, their advisory, and still go below the guidelines and give close to a sentence that you probably would have gotten without going to trial. I think one of the good things, depending on the case, about going to trial is, sometimes if you plead guilty, you got the facts that the government puts into the written plea agreement, or the facts that they present at sentencing without even putting any witnesses on. And they sound bad, but if you actually go to trial and you hear witnesses testify about it, and you kind of get a better idea of what actually happened. So even though the guidelines are higher, the judge has a better idea of what happened. So they might be looking to be more lenient on the defendant. And, it doesn't happen very often, but I think that's one of the things that I consider when advising my client whether to go to trial or not.
It's really heartening to hear that. I have never heard of a federal judge admitting that the sentencing guidelines are really just advisory and that they're just guidelines. I've heard defense attorneys make arguments and judges, rule within the guidelines, but I've never heard of in any of the interviews I've watched of judges actually going beneath the guidelines and making these contextual decisions. I hope it's just because of selective research and not because that is in fact so rare. That would be a sad statement if that was the case. Let me ask you this. What do you think? I ask this to everybody I interview, and we've gotten at it a little bit when we talked about Ed Genson. But what do you think makes a good lawyer into a great lawyer? I understand, I've been led to understand that it's a series of small adjustments, but what are some of the adjustments that have to be made?
Every person, every lawyer is different. I'm going to go back to what I told you before. It's what separates the great lawyers from the good lawyers is your ability to prepare a case. If can you sit there and go through everything 10, 20 times, however many it takes to really know everything? Because if you know everything, you could adjust at trial. But if you only focus on a certain amount of things while you're preparing, you're going to be lost if something comes out of left field. So I really think that's what separates them. Obviously, some people have natural ability. Some people are better at public speaking. Some people are more charming, for lack of a better word, and have a way with the jury that others don't. But at the end of the day, none of that matters unless you know your case better than everyone else in that courtroom. And I really think, at least I can only speak for Eddie because he's the only one I worked with and saw firsthand, but I haven't seen anyone prepare as much as he did for a case. I mean, he would look at things that people would tell him are irrelevant, have nothing to do with the case, but he'd still want to study it just so he'd know it. And I don't want to call people lazy. I think there's a lot of good lawyers, but there's a lot of lazy lawyers. And I've been guilty of being lazy at certain times. I think everyone has, but if you want to be one of the better lawyers in the city you practice in or in your practice area, you got to work harder than everyone else. And that's what's going to separate you. Even if you don't have, some kind of natural ability that someone else might have, your work ethic and your preparation is going to separate you from the pack.
Mr. Glozman, I think that this is a good way to end the interview. I want to thank you for your willingness to participate and also for the insights that you've lent our viewers and honestly myself. I've learned a lot from you. Any book suggestions you have, any trial transcripts I should read, let me know.
Absolutely. It was a pleasure being on here, and hopefully me and you could try a case together soon.
Yeah, absolutely. I look forward to it.
Sounds good. Take care.
Take care.